The trial within a trial in the Senzo Meyiwa murder is expected to continue tomorrow. Last week, a number of police officers were on the stand detailing the procedures taken in extracting confession statements from accused 1 and 2, Muzi, Sibiya and Bongani Ntanzi. The defence maintained that Sibiya and Ntanzi were tortured into confessing. Now, to reflect on last week's developments, I'm joined by Nthabiseng Dubazana, a legal analyst. Nthabiseng, appreciate your time. Just give us an idea from your perspective of how the last week went in the Senzo Meyiwa case.
I'm of the opinion that last week was a lot of information that showed that there's a lot of contradiction that is happening between the police officers and how the accused persons were, especially accused number 2, was then removed from custody to go and do pointing out here, and then, being held in custody for other matters and then being taken out to deal with the Senzo Meyiwa case, which is not unusual. It actually happens quite often. But my thing is that the manner in which this confession seems to have been extracted from the accused doesn't follow procedure. So if we look at, she confirms that the attorney was present when the accused was giving his evidence. What usually would happen in that situation is that if the attorney is indeed present, we need to hand over our FFCs, or at least a copy of it, but that is a fidelity fund certificate, to show that you're still registered with the LPC and you're still legal, so to speak, in order to give such advice, and also to see that you're still in good standing with the court and you are indeed an admitted attorney of the High Court. So now those things did not come into fray, so you start wondering if the name that was presented was indeed a true name of an attorney, and if not, therefore it means that the information that was given from the accused with the assistance of an attorney might not be as reliable. And the police officers that were there, some of them have confirmed that they were heavily armed, but yet this person was willingly giving information. It brings a lot of question marks in terms of how this confession was done.
Now, can you explain the defence's argument that the accused were beaten and coerced into confessing, and if at all it impacts the admissibility of their confession statements?
100%. So in terms of Section 217, 218, 219 of the Criminal Procedure Act, a confession has to be freely and voluntarily given by the accused person. It has to be reduced to writing, and it has to be done in front of a peace officer. That's why you see Advocate Mushololo always emphasizing what rank you are, what do you do, are you a peace officer, what is your understanding of what a peace officer is. These things are vital. And if it does come to light that at the end of this trial, within a trial, that the accused person that gave the confession, or if there's multiple, gave their confession under duress, then it was not freely and voluntarily given. They were beaten to give that information. And if they failed to do so, either they would have been killed, we don't know, or they would have been pinned with that crime in any event, regardless of them giving the information. So it's very critical, actually, to determine whether or not it happened. And if so, if the court cannot give a conclusive answer in whether or not it happened, the court has no choice but to find in favor of the accused. That's the rule of thumb when it comes to criminal law. If the presiding officer cannot assess what actually happened, who is right and who is wrong in this situation, the benefit of the doubt always goes to the accused person.
Now, there has been talk of demeanor. So how important is the demeanor and behavior of the accused, particularly Bongani Ntanzi? I think this has been talked about in the conversations that we heard in court last week.
Demeanor is quite important, but it's not critical in the sense that it doesn't weigh too much on the facts of the matter and the merits of the matter. But the court can, when assessing the evidence, also assess what the court sees in front of it. So if the accused person is behaving in a manner untoward, that is also noted. There's lots of case law that shows that accused persons, even if there could have been a possibility that there were lack of remorse, all of those things are weighed against them, and they end up being convicted by virtue of the way they behave in front of a presiding officer.
Now, could you provide insights into the process of investigating the traditional healer that accused, that are allegedly consulted with, and why is this information relevant to the case?
I think it is circumstantial evidence. I think the state is trying to connect the dots here. They're saying that the accused, before committing the alleged offense by killing the deceased, went to go see the traditional healer and went thereafter for same. So in other words, he went there to go gain strength or courage in order to commit the offense. And then when it was done, he went there for cleansing. So if they're going to call the traditional healer to come and confirm this, then that's the causal link that is being created there, that's going to lead to circumstantial evidence. So if this traditional doctor is not bound by any doctor-client privilege of sorts, then he or she will come and confirm that yes, indeed, accused did come to me, requested this because he intended on committing a certain crime. But if he cannot confirm that the crime was indeed to kill Senzo Meyiwa, then it might be a fruitless exercise. So I think we need to just see where the state is going with this line of argument.
So there are a lot of issues that seem to at least confuse the general public. Now, let's talk about how this information presented and how this information presented might affect the overall outcome of the Senzo Meyiwa murder trial, especially with regard to admissibility of confession statements and the credibility of the accused.
So, if at the end of this trial, within a trial, it is, let's play devil's advocate, it is accepted that indeed the accused persons did indeed give a statement and it was freely and voluntarily done, then that's going to be used against them going forward, because whatever they are going to say when it's their turn to now give evidence, that statement is going to be used against you to say, but you said this in this particular situation, now you are uttering these words here. Which version should the court accept to be true? That is, if the court decides at the end of this trial, within a trial, that those statements were done in the correct manner as required by the Criminal Procedure Act. But in the event that it is not done correctly and the court concedes that and then says that it is not admissible, now the state has to prove its case, or not that it wasn't going to, but it's now stuck with a situation wherein they have to work harder to prove that the accused person did commit this offense, because they're relying very much on this statement to prove that the accused person did indeed commit this offense.
Now, I'll pick something up here. It says, at one time, accused number 2 told me that he's a great Zulu dancer who is capable of putting his foot under his armpit. So let's talk about the potential implications of the accused behavior, such as Ntanzi's claim of being an excellent Zulu dancer in the context of the trial. I mean, just how relevant is this information, and what does it signify?
I don't see what the probative value of that information is. I don't know if the state is going to add more to that evidence. I don't know what they're trying to do. Because at the end of the day, what we're trying to do here is to prove that the accused person did not give the statement freely and voluntarily. What he can do as a Zulu dancer, if his foot can go behind his ear, it's really irrelevant unless the state is going to say that the accused person's flexibility, he can contort himself in certain positions, which will then make rise to him possibly lying about being abused or assaulted as a result in order to give this confession. I don't see how they link to this particular situation that we're dealing with.
Well, interesting that we have it in there nonetheless. Nthabiseng Dubazana, legal analyst. Appreciate your time this afternoon.